Joining me today is Christopher Lachey of Christopher Lachey Law in Mint Hill, North Carolina. He works with families on estate planning and probate, guiding his clients through the process so it seems a little less overwhelming. Christopher, thank you for being here today. I appreciate it.
Yeah, thank you, Michael. One point of clarification. My name is Christopher Lachey, but my office is called CW Lachey.
Let's just start with your story. How did you sort of get started in estate planning?
So I started before even law school, I was a banker. I worked for Wells Fargo, and I felt like I wasn't really doing much of an impact on anything. It was a sales job, and I didn't care for it. When I went to law school, almost on a lark, I said, well, this is something I had been thinking about doing for a while. And growing up, when you're a kid, sometimes you hear about lawyers from your parents or adults around you. It's this thing, it's like a doctor, it's a dentist, it's a chiropractor, it's this professional that has to go to school for a long time, and you really don't know anything about what they're supposed to do. But you see it in movies and you go, okay, that's gonna be pretty cool. I'll scream objection, and everyone will say, oh, thank you for getting my kid back.
Right.
What ended up happening in reality is when I hit the pavement as an attorney, as a new, fresh faced attorney, I hung my own shingle and I made a connection with a local gun store in Mint Hill, Bull Moose Guns. And he said, I've got some people here that need your assistance and want to talk to you about Class 3 firearms. So the NFA Trust, National Act of 1934,
Right.
and National Firearms Act, that's things like short-barreled rifles, short-barreled shotguns, suppressors got added on, and that got my foot in the door for estate planning because you end up creating a trust, a revocable trust instrument. And so I started researching this, I started drafting these things. And then people said, well, how do I pass other property to my families? And I started getting into estate planning for them. And it just became a personal relationship with these individuals and their families, and then being connected with them and saying, all right, well, now that I've done your estate plan for you and your kids and then your father, and then they come back to me a couple of years later and say, oh, my dad passed away,
Right.
or my mom's not doing so well, can we need to get guardianship? And that's what got me into the entire realm of estate planning.
Right. Well, it sounds like you've found your passion.
Oh, it's fantastic. I love it. I love it to death because with this, what's the saying? An ounce of prevention is worth a pound of cure. Just getting any sort of document, any written instrument, I tell people, like, if it's on a cocktail napkin, bring me the cocktail napkin. I want to see something.
Right.
It's so important to have a written instrument for your wishes, for your own personhood, how you want to be treated in your incapacity, and also who's going to get your belongings when you pass away. Because if you don't write it down, someone's going to get it.
Yeah, it's amazing how that happens, right? A lot of
Mhm.
miscommunication can happen too when things aren't written down. Let's sort of talk a little bit about estate planning then. So for a family that's sort of watching this video and they're thinking about estate planning, they're not sure whether they want to do it or not, if it's the right thing
Mhm.
for them. What's the number one mistake you often see people make that causes trouble in the future for family members that are left behind?
Being your next of kin does not automatically mean that you have decision-making authority for somebody when they're incapacitated for financial and medical decisions. People forget that their own durable power of attorney and their own healthcare power of attorney is probably the most important thing because they go, I'm just so worried about my kids getting my stuff. Your kids will inherit your property most likely. What about when you can't make your own decisions? And people say, I don't need that power of attorney. I don't need that healthcare agent. You do need those because that helps prevent guardianships in the future. It also allows people to have an agent that can communicate with them when they're out of country, when they're out of state, and when they're out of their own mind, effectively when they become incapacitated. Those are forms that are just completely missed and they're neglected.
Right. So it sounds like they're missed quite often, that it's a common problem.
Yes, yes. There are other issues with estate planning documents where people will bring me incomplete estates. So someone will say, "Oh, my father had a trust. Hand me a document," and I'm looking at it, and it says, "Yep, everything's in my family trust," and it says Dad's trust, and there's a dollar staple to the back with a rusty staple, and I say, "Show me the bank accounts," and they say, "All right, here are the bank accounts," and it says Dad's bank account. Show me the car. It says dad's car. Show me the house. It says dad's house.
Yeah.
You don't have a trust. The trust has never been funded. We have to open up probate to get the property because the bank's not going to take that trust and say, oh, sure, let me just write you a check.
It sounds like there could be a lot of disappointment on the heir side if they don't do all this paperwork up front and make sure the wishes are declared and written down.
Absolutely. Communication is key. When you have this conversation with your parents, with your kids, with your aunt, uncle, grandparents, being clear is the most important thing. Be transparent with them about what your wishes are. I want you to take me off life support when. I want your brother to be my durable power of attorney, but I want you to be my healthcare power of attorney. I want you to have this specific thing, and I'm going to put it all in writing. And it's all in the firebox in my closet. That's where you can find it after I pass away.
Yeah, sounds like it makes it a lot simpler when that time does come, the loved one passes.
It does. It does. So much simpler.
So, in your experience, what do you think is the number one cause of families not taking the time to sit down and plan in advance or talk about their wishes or getting them written down?
I think people are scared. I think people are scared to face the reality of their own mortality.
Right.
It's what do they say? Only thing you can count on in life are taxes and death. We know it comes for us all, sure, but just plan a little bit, put it in writing, and it's then you've relieved yourself of that pressure.
Right.
I associate it with there's a storm on the horizon, it's coming. You haven't mowed your grass all month, and you know that when that storm gets here, that grass is going to be even worse than it is now, and it's going to be a mess for your family, whoever needs to clean it up. If you could cut your grass one time, never have to cut it again for the rest of your life, wouldn't you want to do that?
Absolutely. Yeah. That's good advice. Absolutely. So I'm sure over the years of your practice, you've seen a lot of people come in with myths or misunderstandings about estate planning and the estate planning process. What is sort of one myth about estate planning that you wish families really sort of understood better?
Just because you're married now does not mean the property you bought when you were not married passes automatically to the surviving spouse.
Okay.
You have a co-tenancy, which means 50-50 ownership. And you get married 2-3 months later, 2-3 years later, and you don't update that deed, you still have a 50-50 ownership, which means it doesn't pass to the surviving spouse automatically upon the passing of the first spouse, which means that when you go to sell the property, here in North Carolina anyway, the insurance agencies, the closing attorney, the buyer's agent, they're going to say, sure, I see that it wasn't tenants by the entirety, joint with right of survivorship. Show me the notice to creditors. Show me that you opened probate. Show me that you don't have any creditor claims against this property. Okay, that's 3 for 3. I got to go talk to an attorney. And yeah, we got to open up probate. We got to do a notice to creditors. It has to run one time.
Right.
And then the insurance agencies, they'll allow the sale to go through. You know, I can't speak for them. That's just been my experience. Then the sale can go through. We keep everything in escrow. And then at the conclusion of the notice to creditors, then you can go ahead and distribute the remaining assets of that house. But that means that they don't get a pile of money from all the equity, and that slows everything down. Even if you could list it for sale, you can't close on the house until you have notice to creditors, until you have that probate run.
It sounds like that could create a lot of problems for the beneficiary or the person that's inherited or supposed to inherit the property, the surviving spouse. That could be a lot of problems if it's not done properly up front.
Absolutely. Well, you know what happens a lot of the times is one of the parents will pass away, and then they say, "All right, well now we got to take care of mom or dad. Mom or dad, you're going to move in with us, or mom or dad, we're going to move you into a facility, and we're going to fund it by selling the house."
Right. For a family that hasn't done any estate planning yet, what's one of the simplest first steps they can do to sort of get to protect themselves or maybe protect their loved ones?
Find out who your favorite child is. The most important thing is to, if you're married, have a conversation with your spouse. What happens when when I'm incapacitated? take inventory of what you have. Wouldn't it be a shame if this fell into the wrong hand? Wouldn't it be a shame if this got caught up in some sort of turmoil between our kids after we both pass away? Consider that maybe you want to have a sit down conversation with your adult children and say, here's here's the jewelry, here are the firearms, here's the advertising paraphernalia such as commemorative plates and gas pumps, whatever people collect.
Right.
Hey, does anybody want any of this stuff? And just have a conversation. You don't have to be a downer about it. It does Just because you're having this conversation doesn't mean Christmas is ruined. This
Right.
is usually when people have conversations. It's either following the death of a family member, or it's, hey, we're all together during the holidays. It's okay to have that conversation.
It sounds like it's really important to have these important conversations before you're so emotionally involved, or there's some kind of traumatic event that you're like heightened emotionally. That's really not the right time to have a conversation, is it?
Oh, exactly. I mean, you want to be proactive, not reactive,
Right.
right?
I mean, you probably see a lot of families come in that didn't have those conversations, that are probably all over the emotional scale, and not sure what to do or where to go.
Well, that's what happens. They say, well, dad said I was supposed to get X, but now dad passed away without a will, so brother, sister, other brother are going to split X three ways. I'm sorry, that's just the way it is. If you want to make your siblings an offer, we can negotiate, we can try and figure that out. But yeah, you're going to end up with three-way ownership on a piece of real property, or you're going to have three people can't drive a car at the same time. You got to figure it out. So a lot of the stuff just gets sold.
So it sounds like that's sort of guided by a state statute or something. There's some kind of rule or some kind of law somewhere that says that if there's not a will explaining how things are supposed to be distributed, there's, this, I guess the government tells you how they're going to be distributed.
Yes, yeah. So that's the thing. If you don't have a plan, don't worry. The government has a plan for you.
Oh. And that's probably
That
the
should,
best plan in the world too,
oh
right?
my gosh, that should drive everybody, wow, to a law office to get this stuff done,
Right.
knowing that the government has your best interest in mind. So it is. It's intestate succession. North Carolina says whatever you put in a will, that's fine. That's your business. As long as it's drafted to our specifications under statute, you're good. If you don't have that, then here's how it's going to pass. And anyone can look this up. Type in North Carolina intestate, intestate,
Yeah.
intestate, which means without a writing. North Carolina intestate succession.
Okay.
And you'll find a lot of great links, some great charts that say, are they married with kids, without kids, how many kids, brothers, sisters? And those charts are derived from the statutes in North Carolina that say, here's how the property is going to pass to people when you don't have a will. And it's very simple usually.
Right.
If you're married and don't have kids, it's going to go to your spouse. But if you're married and you do have kids, it starts to get messy. If you've
Right.
got one kid and you're married, that house that you didn't title is joint with right of survivorship, you get 50% of your spouse's interest. So you've got 50%, then you get your spouse's other 50%. Now you own 25%, 75% of the house.
Right.
Your kid, or rather the decedent's kid, owns the other 25% of that house. So probably not a big deal when that's your biological child that you shared with your spouse, but what if you're the spouse of a second relationship? What if that child is alienated? What if you
Right.
don't have any relationship, or perhaps that kid blames you for the breakup of his parents, and you ended up marrying his mom or dad, and now he's mad at you. He can try and shut you out of that house. He can really mess up your day by
Wow.
going to take possession, force the sale, and ultimately you could end up living in that house for the rest of your life, but you don't technically own it anymore.
Right.
It's all covered under statute.
In your experience, how often do you see old I guess rivalries or old beasts come up, with families when someone passes
Weekly,
away?
weekly. Yeah. I did a lot of family law in my early days of being an attorney. You know, I thought, wow, this is crazy. The amount of drama and anxiety is just ridiculous. This is untenable. I can't keep doing this. And so I started backing out of my family law, and I really ramped up my estates and probates. And I got to tell you, nobody will let you down like family.
Yeah.
It's just as anxious. It's just as combative when people are mad about
Right.
what the cousin got or what the brother got, and they got disinherited.
That's sad. That's got to be sad when you see that tears families apart. So apart, I imagine. So, so it sounds like communication is definitely the key to this whole process. You need to sit down with your loved ones, tell them your wishes, and get it in writing, and then get it to an attorney like yourself that can make those wishes or those desires official.
That's what we do. We make wishes come true.
When a family finally sits down with you, what do they usually say they wish they had done first before they or wish they had done sooner?
The thing that I wish they would do had done before they came to see me, come to see me before your family's health gets worse. It's very difficult when I tell people, I'm sorry, I can't do an estate plan for your father. His Parkinson's is so bad, he is not cognizant to create an estate plan.
Right.
Can't do it. All we can do now is file for guardianship, and his property is going to pass intestate. That's a very difficult situation to be in. Hey, you want to put your mom into a mental care facility, a memory care facility, and you're doing that tomorrow, and so you want to put everything in a trust today. I'm sorry, I can't get you the results you want. You needed to come to me 5 years ago. When people have progressive disorders, that diagnosis should trigger your response to go to an attorney. If you have not already gone to one, go to one. The moment you have a progressive disorder diagnosis, look at your estate plan. Are these the people you want in charge? Are these still your wishes? That's when you need to take action. That's almost your checkered flag, because
Well,
anything past that is going to get very difficult. See, what happens is when you have a diagnosis, let's say you've got an early onset dementia diagnosis, and you go pass a lucidity test with my office. I ask you, are you oriented to time? Who's the president? What year? Who am I? What are you here for? We run through a gamut of questions, and we say, all right, he understands what's going on. And this is what happens. People with progressive disorder still have lucid moments. It's carved out in the law. So uh, I'd like to get letters from doctors that say, hey, he's okay talking to you. He's okay making a financial plan and doing this. But what will almost always happen is when you create that estate plan, someone's going to be rumbly about it. And either it's going to be before that person passes away, or it's going to be during the probate, and they're going to say, I'm going to file a caveat to that because he made that because he was under pressure, undue influence. He didn't know what he was signing. He had dementia. And I'm going to try and bust out all of this information that says this will should be invalidated. And that's because they didn't have a clear communication with their family and they waited too long. I'm not saying that we can't win. We're saying it's going to be time and resource expensive.
so something that could have been, if it had been done earlier when they before the cognitive issue had been diagnosed, it would have saved them a ton of money on the back end if they just done it earlier.
Absolutely. Absolutely.
Yeah, and I imagine you see that happen a lot.
Do
Yeah,
Unfortunately, that is what it is.
yeah, yeah. It can be a sad process for some families, I imagine. I've seen it happen a
Mhm.
lot too. So, well, Christopher, this has been really helpful. I really appreciate you again you taking the time. For someone that's watching this, a family that's watching this video, and they're wanting to sort of go to the next step, they want to reach out to you. How's the best way for them to reach you?
Oh, okay. Well, you can blow up my phones, or you can email me. That's going to be info at cwlesq.com. Info at cwlesq.com.
Okay.
Phone
Your
number,
phone number.
yeah,
Yeah.
phone number 704-940-0465.
Okay. And I imagine you probably have a website. Give me your website too, just in case.
Sure, I'll make it easy. cwlesq.com.
That's pretty easy. Any other parting advice you'd like to give, or anything else you'd like to say to someone watching?
I would say if you don't think you have anything worth passing to another person and you say, that's why I don't need an estate plan, consider being a little bit more selfish. How do you want to be treated in your incapacity? Even if you don't have anything to give away, you still need to respect yourself enough to tell people how you want to be treated and to put in paths that will allow you to be treated the way you want to be treated. That's that durable power of attorney and the healthcare power of attorney and an advanced directive such as a living will when you want to be taken off life support. Those are three very important documents people forget about.
Okay, great. Well, thank you again for your time. Greatly appreciate it, and hopefully talk to you soon.
Sounds good, Michael. Thank you for the opportunity.
Yes, sir. You take care. Bye
You
bye.
too.